Mr. Stewart, does your argument, you've talked a lot about how this doesn't actually stop him from speaking because he can still speak even though he can't register the trademark. So does your argument depend on the validity of his mark under state law? Because this is where I'm going with this. He can't register this, but there is a speaker-based discrimination. Could Trump come in and register that trademark, because obviously he can register it and he's giving his consent, and then that trademark be valid, and so it stops Elster from having T-shirts or signs or anything that says it?
Well, I mean, the limitation on Donald Trump's ability to do that is that, unlike with patent and copyright protection, where you can create the thing and exclude others from doing it, even though you're just sitting on it, it is a core requirement for initial and continuing trademark registration and trademark protection that you have to assert at least the intent to use the mark in commerce, and then the PTO does periodic checks.
So he does, because he wants to stop this, and so he does do it in commerce, but he does it, in a very limited way.
I mean, if he can satisfy the requirement of use of the mark in commerce, and he certainly wouldn't be barred by the living individual clause, and assuming it was perceived as a source identifier, then yes, he could accomplish that in the way you suggest. But the crucial point would be he would have to use the mark in commerce. He couldn't just reserve it without using it.
Would there be a constitutional problem then?
I mean, I don't think so, because...
For Elster?
When you say for...
Well, I mean, then Elster can't, sell this on T-shirts or, I guess what I'm saying is, if he then can't express the speech, put it on T-shirts, sell the T-shirts, sell mugs, whatever, is there any speech problem then, because he doesn't have another mechanism, even though he can't register the trademark of expressing his message?
I don't... If this was properly registrable as a trademark, and that would require in particular that it be perceived by consumers as a source identifier, then I don't think that there would be a constitutional problem, and that's something like the same problem that arises in infringement litigation generally. That is, whenever you have an infringement suit, you're seeking to hold somebody liable for expression on his goods, and the justification is there's no First Amendment protection for false or misleading commercial speech, and if a particular combination of words or images has acquired trademark protection, is understood to be a representation as to the source of the goods, then you're putting the same words or images on your own merchandise is making an implicit representation that they were manufactured by somebody other than you. Now, whether there could be some as-applied constitutional claim on the theory that if this was all a ruse, if Donald Trump's only motive for obtaining trademark registration and then engaging in limited sales of the goods was to prevent Mr. Elster from selling them, I've never seen a case raising that fact pattern.